Oh, hi, Shane. That's fine. Yep, I see that you said that. Okay, I'm going to move us on to next slide. Alrighty. So we are Change Peoria. We're going to go over the impacts of money bond and the pretrial incarceration, how money bond works, how the Pretrial Fairness Act itself, how pretrial freedom makes our communities safer and what we're up against, as well as how you can get involved. And all right, so the Illinois Network for Pretrial Justice launched in the summer of 2019. The network, like I said a little bit earlier, is comprised now of about 50 organizations or more from across the state of Illinois, representing 9 counties and several statewide organizations and networks. Members stretch from Carbondale to Waukegan to Rockford and Champaign, here in Change Peoria. We're happy to be one of them. It's been nothing but exciting to be involved from just getting involved with them has been just absolutely fast paced and super fun. So we're happy to share what we've got with you guys today. All right, and so a little bit about us. Change Peoria is a grassroots political organization formed in 2016. We empower people in the metropolitan Peoria area to develop accountable, transparent, and responsive governments for all by ensuring inclusivity, justice, and equity. Our methods include backing public office candidates, supporting issues, public education like this, and voter engagement. Change Peoria is building working class power by promoting social and economic justice in our community. We believe that everyone deserves equal opportunities and a fair chance at success. At Change Peoria, we believe in the power community and the importance of standing up against injustice because everyone deserves dignity and to participate fully in society. So that's really sums up perfectly why we're all here today. And I will take this opportunity to pass it on to David.
All right, and let's admit Chris here. Thank you, Chris. Looks like you might have joined another group or from another device or joining another associate of yours. So thank you for joining us. I'm going to get into some of the effect of money bond in Illinois here. Every year, more than a quarter of a million people are incarcerated in the 92 county jails in Illinois. 90% of them are being jailed pre-trial, which is much higher than the national average of 67%. A majority of these people are incarcerated simply because they couldn't afford to pay that money bond. And when a person goes before the judge previously had the ability to either release the person on their own recognizance with an I bond, which means they're released pre-trial and don't have to pay money, deny that person a bond altogether, incarcerate them if they think they're not safe to be released or are a flight risk, or set a money bond that must be paid to secure their freedom. And judges also had and still will have the ability to set conditions on a person's release, which can include everything from check-ins with a pretrial service officer to house arrest with electronic monitoring. And so when a judge sets a money bond previously, the court has declared that person for release, but the judge has legally determined that the person is not a danger to the community, and the only thing between that person and their freedom is the access to money. This is a wealth-based punishment inflicted while people are still presumed innocent. If these individuals had more money in their bank account, they'd be at home, able to keep working, supporting their families and other loved ones, and making positive changes. The myth of money bond is that it ensures the person will show up for court once they pay them, but instead, judges are setting money bonds far above what a person can pay, often intentionally as a way of keeping them from being released. This practice is unconstitutional because it denies people due process and discriminates against poor people, Black people, and others of people of color. There is no evidence that money bonds improve appearance rates, and bond funds have even found that people who they bond out come back to court at a higher rate than people who pay their own bonds. That's because it's support and simple assistance like phone reminders that make the biggest difference in helping people make it to court. And like I said, that's all what the past has been. Pretrial Fairness Act takes effect tomorrow, the 18th, and money bond is over. So tomorrow, Illinois I'm gonna go through actually a little statement from the Pretrial Justice Network. Tomorrow Illinois implements the Pretrial Fairness Act and becomes the first state in the country to completely end the use of money bail. This historic moment is a result of over 6 years of organizing by members of the Illinois Network for Pretrial Justice. Since this campaign began in Cook County in 2016, tens of thousands of people across our state have taken action to secure this victory and end one of the most blatant racial and economic injustices in our criminal legal system. The Pretrial Fairness Act provides Illinois communities with the opportunity to begin healing from the decades of damage caused by wealth-based incarceration. Every year, the money bond system extracted millions of dollars from our state's most marginalized communities. For years, community members were forced to pool resources together to purchase their loved one's freedom while they awaited trial. Despite these efforts, tens of thousands of people lost their jobs, housing, and even custody of their children simply because they couldn't afford to pay their freedom. Tomorrow, Illinois begins the process of reducing pretrial jailing by taking the price tag off of one of our most fundamental rights, the presumption of innocence. As Illinois reduces the number of people incarcerated in county jails, it is essential that we work together to ensure that any economic benefits from these changes are passed on to the communities most harmed by pretrial jailing. Across Illinois, Black people have been disproportionately jailed by unaffordable money bonds. Communities most impacted by crime have also been those most impacted by wealth-based jailing. This has created a cycle of trauma that we have the opportunity to stop. As a state, we must ensure that the money once used to jail those who couldn't buy their freedom is funneled into essential services like healthcare, community-based substance use and mental health treatment, affordable housing, and quality education. This moment also represents an important step towards ending mass incarceration. Money bond does not just increase the number of people being jailed awaiting trial, it has also played a central role in rising prison populations. People jailed pretrial are more likely to be convicted and serve longer sentences than people who await trial in the community. Over time, the Pretrial Fairness Act has the potential to reduce the number of people incarcerated in Illinois' prison system. Community organizations across the state now begin the long, hard work of holding the courts accountable to the changes included in the Pretrial Fairness Act. People across Illinois are gearing up to observe court and work with their local stakeholders to ensure reforms are properly implemented and achieve the primary goal of reducing pretrial incarceration. The Illinois Network for Pretrial Justice is also preparing to stop the expansion of other forms of pretrial punishment, such as house arrest with electronic monitoring and pretrial supervision. The forces that have relentlessly tried to stop the Pretrial Fairness Act from taking effect will not be deterred by the law's implementation, and we must remain vigilant. Our thousands of members across the state stand ready to work with our legislative allies to protect the Pretrial Fairness Act and stop any further attempts to roll it back or repeal it. On this momentous occasion, the Illinois Network for Pretrial Justice thanks our legislative champions, the stakeholders who've been working together to prepare for our implementation, and the tens of thousands of people across the state who repeatedly took action to pass and protect the Pretrial Fairness Act. To our supporters around the country, we thank you and are ready to stand with you as you work towards sending money bail and winning pretrial freedom in your communities. And so now we'll go into some of kind of what got us here and why we fought so hard to get here. And the harms of pretrial incarceration. Incarcerating someone pretrial has significant consequences on the rest of their life. Just 1 or 2 days of pretrial incarceration have been found to significantly disrupt a person's life and set off a destabilizing domino effect, causing people to lose their jobs, their housing, and even custody of their children. After a month in jail, people lose access to crucial public benefits they're receiving, creating gaps in coverage for things like health care and Social Security benefits when they're released. The first few days are also the most dangerous because many people die in jail within the first 5 days. Death is a particularly high risk for the most vulnerable, including people with mental health needs or people who use drugs. And being incarcerated pretrial makes it harder for a person to participate in their own defense, like I said. People in jail are more likely to be convicted and they serve longer sentences than people who are or who are free while awaiting trial. The pressure of pretrial incarceration can lead to someone accepting a plea deal simply to get out of jail, a deal they likely would not have taken if they were able to maintain connection with their friends, family, and community. Locking people up who are presumed innocent is also undermining the system's own stated goals of creating safety and ensuring people come back to court. People who are in jail pretrial are more likely to be rearrested in the future. That means jailing people is literally creating more crime. This makes sense when we think back to all the negative impacts jail has on someone's life and how it keeps them from maintaining positive relationships or staying connected to resources that help them succeed, not to mention all the negative things that you can learn in jail from other inmates. The less we destabilize people by jailing them and instead support them with resources in the community, the better off we all are. And so a little walkthrough of how we got here and the principled walkthrough of the Pretrial Fairness Act. Like I said in the statement from the network in January of 2021, the Illinois General Assembly passed the Pretrial Fairness Act. And in February of that year, Governor Pritzker signed it into law. The law was set to go into effect in January 2023. However, due to some frivolous lawsuits leading to the need for Supreme Court review, were delayed, and it's finally going to be going into effect tomorrow, September 18th, 2023. The Pretrial Fairness Act doesn't just end money bond, it transforms Illinois legal system and dramatically reduces the number of people incarcerated pretrial. This historic legislation restores the presumption of innocence and will make Illinois safer. We're going to take a walk through really quick the law using the principles of bond reform that the network set up. And these are a set of principles that the Illinois Network for Pretrial Justice has used to guide our advocacy work, and we feel very strongly that these principles line up perfectly with what the bill accomplishes. And first is money is never a determining factor in whether someone is free pending trial. The Pretrial Fairness Act completely abolishes the use of money bond in the state of Illinois. Wealth-based and pretrial incarceration will become a thing of the past, and people will only be eligible for pretrial incarceration after a robust, individualized hearing that reflects the seriousness of the decision. No longer will the size of a person's bank account determine whether or not they walk free or are caged while fighting their case. Number two, that release is the norm and detention is the carefully limited exception. And the Pretrial Fairness Act eliminates money bond and restores the presumption of innocence by ensuring that the majority of people arrested every year are not eligible to be jailed while still awaiting trial. The bill creates what's called a detention net, which dictates that only people accused of more serious charges may be ordered detained at their initial bond hearing. Most people are arrested for misdemeanors and are unlikely to be jailed even after they are convicted. The Pretrial Fairness Act ensures that those people don't lose their freedom before trial. In addition, police are required to issue citations similar to traffic tickets for most ordinance violations and similarly non-serious charges. This means many people will not be arrested at all, ensuring that they don't suffer from the harms we described earlier. A problem with our current system is that many people spend time in custody for minor charges just because they're waiting to see a judge to set their bail and grant them release. Studies show that many of these worst impacts of jail happen after the first 24 hours, including the increases in future rearrest and missed court dates, which makes sense when you consider that most of the people only get one no call, no show at work before they're going to be fired. And this means that it's critical to get people out of custody as fast as possible before jail begins to destabilize their lives. Under the Pretrial Fairness Act, a majority of people would be either cited and released with a court date on site, avoiding the arrest altogether, or even if they're arrested, they would be eligible to be released directly from police custody without having to wait up to 70 hours to see a judge. This will allow more people to avoid the devastating impacts that can start to happen after even just a day in jail. And just because a person is eligible for pretrial incarceration does not mean they will be jailed. The Pretrial Fairness Act requires a robust hearing process and raises the standards that must be met before someone can be denied release. We're going to walk through how that process works really quickly here. So, under the Pretrial Fairness Act, the court must be able to prove these three things before incarcerating someone pretrial. That number one, probable cause that the person committed a qualifying offense. Number two, and sorry that these all say number one, but specific, real, and present threat to safety of a person or persons, or a high risk of willful flight. And thirdly, that there are no conditions other than detention that will protect the public from a specific real and present threat to any person or persons, or prevent the accused person's willful flight from prosecution. Under the Pretrial Fairness Act, there are different pathways a person's situation may take depending on whether or not they're facing a charge that falls inside or outside the detention net. So first, we'll go through what happens if someone is facing a charge that falls within the detention net. If someone's arrested and charged with a qualifying offense, and the prosecutor wants to request that they are be incarcerated pretrial, there must be a robust detention hearing. At the detention hearing, the court must be able to prove these three things before incarcerating someone pretrial. There must be a probable cause that the person committed the qualifying offense. They must be found to a real, specific, and present threat to the safety of a person or persons. And this is important because our current system, the general label of danger to the community, is thrown on people just to lock them up pretrial without identifying any specific justification. And this standard requires a real and present identifiable risk. And the legislation also creates a new standard for willful flight. In the past, merely failing to appear in court was used as a justification for incarceration uh, of someone pretrial on the assumption that they'll miss court. But people miss court for all types of reasons, not just willful flight, and including lacking access to childcare, transportation, or simply just not knowing that they had a court date. I know myself, I've missed one because I wrote the date down wrong and ended up with a DUI charge because of it. So this new standard requires the court to show that someone is a high risk of purposely fleeing prosecution, and previously missing a court date alone is not sufficient. Lastly, the court must find by clear and convincing evidence that there are no conditions other than detention that will protect the public from a specific, real, and present threat to any person or persons, or prevent the accused person's willful flight from prosecution. If other conditions can be set that would address safety concerns or flight risk, then the person must be released on those conditions. If and only if no other less restrictive conditions can be found to address safety and flight concerns, then a person may be incarcerated pre-trial. But we imagine relatively few cases will rise to meet all of these standards, especially compared to the detention rates that resulted from unaffordable money bonds. The Pretrial Fairness Act also increases the standards that courts and prosecutors must meet before Illinois or before someone can be incarcerated pretrial in Illinois. Um, and so that's the pathway if someone is charged with the qualifying offense, which represents a minority of cases. Most people charged are going to be charged with non-qualifying offenses. In these cases, they'll either be released directly from the police custody or given a conditions hearing where the court must choose the least restrictive conditions necessary to safely release them. This is what will happen in a majority of the cases under the PFA. The creation of the detention net and increased standards required to justify pretrial detention protect the presumption of innocence for everyone and will dramatically reduce the number of people in jail in Illinois. Later, we'll talk a little bit about how this will make all of our communities safer. And so back to our fundamental principles here. Number three being that accused people are viewed holistically and risk assessments aren't used as substitutes for individualized decision making. Risk assessment tools are already permitted in Illinois law and are used in several counties. They're heavily relied on by criminal legal system stakeholders who want to move away from money bond. While our network has lots of concerns about risk assessment tools because they can recreate racist structures with no out, we couldn't exclude them at the same time that that we ended money bond in Illinois. We did try to mitigate their harms, though. And the Pretrial Fairness Act limits the use of risk assessment tools and creates new protections for accused people if a risk assessment tool is used. The Pretrial Fairness Act prevents risk assessment tools from being used as the sole basis for denying someone pretrial release, and it also requires that defense attorneys be given information about the scoring of any tools used, and explicitly permits the accused person from and their lawyer to challenge the validity of the tool being used. Moreover, risk assessment tools often score people on their likelihood of missing court, and the PFA notes that previously missing court is not enough reason to mark someone a high flight risk, remembering that new willful flight standard. And number four, that courts should help accused people attend court hearings and restrain their freedom as little as possible while they're legally innocent and awaiting trial. Um, it reforms the warrant process. Uh, Currently, missing a court date in a felony case means a warrant must be issued for your arrest, and you'll likely be reincarcerated, possibly all the way until your case ends. This policy punishes people who may miss a court date for a variety of reasons, such as a lack of childcare, transportation issues, or simply not knowing they had a court date. It also provides no incentive for a person to return to court if they made an honest mistake and just want to resolve the issue, because it threatens people with jail regardless of circumstances. In some jurisdictions, felony cases may take a year or more to resolve. That means traveling back and forth to court, rescheduling work and other commitments once a month for over a year. The chances that someone will make a mistake or find themselves choosing between keeping their job and making it to court at some point in that time are quite high. The Pretrial Fairness Act allows courts to give people who missed a court date notice and a 48-hour window to come in before issuing a warrant. If they come in during this window, they will not go to jail or have a failure to appear added to the record. Allowing people who just missed the court date to come in and make the courts more efficient, or will make the courts more efficient and prevent people from being jailed over simple mistakes or access barriers caused by poverty. Uh, the Pretrial Fairness Act also removes or limits some of the pretrial conditions. Most significantly, the Pretrial Fairness Act bans pretrial drug testing. It is no longer a permissible pretrial condition to order drug testing, and the entire statutory authority for pretrial drug testing has been repealed. This is great because that is a huge violation of people's privacy and a burdensome condition that doesn't help people and just ensures people are penalized while unconvicted. It is currently an automatic and mandatory condition in all cases that an accused person not leave the state without special permission of the judge. This is now permissive instead of mandatory, so it must be affirmatively imposed. And the Pretrial Fairness Act also makes pretrial fees permissive instead of mandatory. And the Pretrial Fairness Act also reforms electronic monitoring. Electronic monitoring is not an alternative to incarceration. It is an alternative form of incarceration. Electronic monitoring removes the jail into our communities, or moves the jail into our communities and turns homes into cells. The Pretrial Fairness Act doesn't eliminate the use of electronic monitoring for people awaiting trial, but it does add important protections and lessen some punishments. Under the current system, electronic monitoring restrictions are incredibly severe and can cause serious harm on individuals on it and their loved ones. People on EM are routinely denied the ability to go to work and are given restrictions that make it impossible for them to work and perform the most basic functions like going to the grocery store, attending a doctor's appointment, or even taking their kids to school. Currently, punishments for even the most minor or accidental violations of EM are severe and can result in reincarceration and even new charges. The Pretrial Fairness Act requires judges to reconsider orders to electronic monitoring every 60 days to see if someone can be released to a less restrictive condition, and also guarantees movement for people on electronic monitoring to complete essential tasks to take care of themselves, and requires people be given movement without any specific justification on at least 2 days per week. It also requires that someone be missing from home confinement for 48 hours before they can be charged with escape. Currently, this felony charge is filed against people for even minor and accidental EM violations. The Pretrial Fairness Act guarantees that anyone subject to house arrest and/or electronic monitoring receives credit for the time toward any future sentence as a recognition that it is in fact a form of incarceration. This is This only sometimes is happening right now, and the Pretrial Fairness Act will guarantee it for everyone. And our point number 5 is that courts should only use restrictive pretrial conditions to ensure court appearance for people who have been proven to be willfully avoiding prosecution. Under the current system, violations of conditions of pretrial release, such as failing a drug test or leaving home for an emergency while on house arrest, may result in reincarceration even if the instances are minor or accidental. The Fairness Act distinguishes between non-serious and more serious violations. It lowers the penalty for many technical violations and requires a violation to be willful before a person can be sanctioned for it. It also creates pathways for less severe sanctions so that people can avoid being reincarcerated pretrial for violations and prevents people from being reincarcerated indefinitely for most violations. And point number 6 is that pretrial practices should be transparent and accountable. We know that the current pretrial practices are harming people across the state, but we don't have good information about what exactly is happening in all of Illinois' 102 counties. What is happening in bond hearings and jails across the state is not currently being tracked. That means that there's no meaningful oversight as to whether or not people's rights are being violated, or even who is in jail and why they are there. The Pretrial Fairness Act will require counties across the state to collect and publicly release data that is happening in courtrooms and jails across Illinois. This provision will be essential to ensuring that reforms are properly implemented. It is also what will allow us to ensure fewer people are jailed and that the counties don't just replace money bond and incarceration in jail with incarceration at home on electronic monitoring or other punitive conditions. So, how pretrial freedom makes our community safer. I said we'd talk about this a little bit later, and now we're here. So, there is no safety in a system where finances determine who is in and out of jail. The Pretrial Fairness Act makes it safer by ensuring that finances do not determine freedom and that a fair process does instead. Reducing incarceration reduces crime because data has shown that pretrial incarceration increases likelihood of future arrest. Jail is an isolating, violent place that further traumatizes people. People do not get help in jail, and the shame, stigma, and hurt that it causes can even increase the likelihood of future contact with the criminal legal system and future violence. Several jurisdictions have eliminated money bail or greatly reduced its use, including Cook County right here in Illinois. Notably, this has been done without endangering community safety and in some instances coincided with an overall reduction in crime. And so let's talk about just the facts about pretrial reforms here. A lot of elected officials will talk about bail reform or people facing nonviolent charges, especially centering people with drug charges. Our vision includes everyone. And so it was important that we didn't leave out people who are accused of more serious things in the Pretrial Fairness Act. We think it's important to explain why. All people are deserving of their pretrial freedom, regardless of the accusations against them. At the foundation of our legal system is the principle that we are all supposed to be considered innocent until proven guilty. This applies to everyone. We need to wrestle with the discomfort we have around releasing people charged with more serious crimes, as caging them is in direct contradiction with this principle. Currently, we are locking people up, sometimes for years at a time, simply because of an accusation. This is destroying lives and tearing apart communities. Today, our system treats people as if they're found guilty until proven innocent, and that isn't right. And that approach is not making us safer either. As we talked about earlier, jailing people destabilizes their lives and makes it more likely that they'll be reincarcerated or rearrested in the future. Just because a person has been accused of a crime doesn't mean that they are a danger to their community. The court currently has the ability to deny people pretrial release if it can be proven that a person presents a real risk to the community safety. While it's easy to focus on a few horror stories, the truth is that most people are not a threat to their community. After Cook County doubled the number of people released pre-trial without paying money, just about 1/2 of 1% of the more than 30,000 people released in the last 2 years have been accused of committing a violent crime while out on bond. Meanwhile, 99.4% of people successfully and safely return to their communities. And so, what are we up against here? And while we're excited for that the Pretrial Fairness Act passed and is being implemented tomorrow, there are still a few things that we need to guard against. One is any changes to the legislation and rollbacks that would cause more people to be incarcerated after it is implemented rather than fewer. For example, opponents may want to drastically expand the detention net, which is the changes that qualify for pretrial incarceration. And it's important that we stand against this for all the reasons being discussed. Being charged with something more serious doesn't mean that someone should automatically lose their right to pretrial freedom. Every person deserves a fair hearing process that gives them the least restrictive conditions necessary to ensure safety. The Pretrial Fairness Act ensures that and must be kept intact. And we're going to spend a little bit of time talking about things we're trying to guard against once the Pretrial Fairness Act goes into effect as well. Uh, One of the big things being, like I said earlier, the risk assessment tools. The Pretrial Fairness Act limited how risk assessment tools could be used in pretrial decision making, but there are still many who want to rely on them to drive release decisions, especially now that we have ended money bond. These tools were developed to help reduce the changes, or sorry, help reduce the chance that judges are making release decision based on their own biases. However, these tools are inherently problematic as they are based on people's criminal records, which we know starts with racist policing practices and contains massive racial disparities. In a lot of ways, the tools are measuring the criminal justice system's response to a person and how they look at and where they live rather than anything about the person. For example, the zip code a person lives within will greatly influence the frequency at which they've come into contact with police and the criminal legal system. The decision-making process practices of judges have been shown to subject to implicit racial biases, classist, and otherwise problematic. But that doesn't mean that we should rely on risk assessment tools that launder that bias into something that is supposed to be objective. Despite these issues with risk assessment tools, they will continue to be used in Illinois for the time being. The introduction of risk assessment tools is something that may happen at either the state level or county by county. The Illinois Supreme Court wants to develop a statewide risk assessment tool that many are pushing for things, or and many are pushing for things to be included in that tool that we know will increase the bias and ultimately deepen racial disparities in our pretrial system. We are going to continue to push against the introduction of new risk assessment tools and for the rejection of ones already in use. False alternatives to incarceration is another thing we're concerned about here. People need resources, not surveillance and monitoring. Many false alternatives to incarceration are being offered up in response to calls to reform of our pretrial justice system. At the forefront is electronic monitoring. Though the Pretrial Fairness Act created and protected more rights for people on EM, we still need to fight against a drastic expansion of electronic monitoring once the Pretrial Fairness Act goes into effect. Many counties in Illinois do not currently have pretrial electronic monitoring programs, but they may try to start them if they can't jail as many people on unaffordable money bonds. We must work to prevent this. The data collected, mandated in the Pretrial Fairness Act will monitor how many people are on EM and help us track this. People must work in their individual counties to oppose creation or expansion of EM and GPS monitoring programs and demand no and new investments in pretrial surveillance. This is one that we've currently are fighting with. The Supreme Court has instituted a system for 70 counties to implement pretrial electronic monitoring for them and manage it for the counties, some of the smaller counties that did not already have it. If fewer people are in jail, the county should take money from the jail's budget to invest in communities, not to get money to find new ways to surveil people in the community. In addition to electronic monitoring, we oppose the expansion of pretrial surveillance and punitive measures that are often administered under the guise of pretrial services. There will be a statewide pretrial service system under the pretrial counties under the Pretrial Fairness Act. We don't want this to result in more money for the courts and for probation departments, and we must oppose that the money for also goes to law enforcement. We want it to come back to the communities, not to the justice system. And right now, most pretrial conditions create a higher likelihood that a person will be reincarcerated while fighting their case. They create rules that people cannot succeed under, and the more rules are applied, the more likely someone is to fail to meet them all. The pretrial justice system should ensure that people receive real supportive services while they are fighting their cases. This means providing what they need, what people need to get out of court, or to get to court, sorry, such as bus passes or even Uber rides, offering flexible court dates and rescheduling, and connecting people with voluntary social services in the community. Um, Accessing services must not, however, become a condition of release that people are punished for not doing. We do not want pretrial services to become a way of that the courts get control over more parts of people's lives, such as healthcare, childcare, education, or jobs. So that brings us to how you can help, and I'm going to pass it off to Sawyer for this.
Let me remember to unmute myself. Thank you so much, David. That was really comprehensive and awesome, and you're got it covered. So now we're on to how we can all help. First off is we really need you guys to write your legislators. So now that the Pretrial Fairness Act is passed, many legislators who have voted for it are facing heavy opposition from the law enforcement, prosecutors, and conservatives. So we will drop a link in the chat for you guys. Um, for you guys to send thank you notes to your legislators who voted in the PFA and scold those who voted against it, essentially. We have been told that these messages make a real difference in Springfield, and we really hope to see an impact coming from those. So, David, if you wouldn't mind dropping the link in the chat for me. Then next, make sure that you sign up for our newsletter at endmoneybond.org and follow us on social media for regular campaign updates. Um, here, oh, my bad. For regular campaign updates, let's see. That's really the best way to find out what we're doing, what they're doing. And we'll talk more in the presentation if you'd like to find out more information or resources related to anything like that. Then we are always sharing content as well, Change Peoria, related to the PFA and pretrial justice reform. Please dig in, learn more, and share this information with your networks, your friends, coworkers, anyone really. We will need an even more robust community of support to stand our ground on this as it goes into law. And as it holds its, tries to hold its own in the next couple years. So it needs all the support we can give it. And then finally, we would love for you guys to join us court watching. This is joining us for the implementation over the next month. So we're looking for volunteers to pair up in groups of two, I believe two, and watch conditions and detention hearings in the Peoria County Courthouse. This is starting September 25th. And we will be hosting a virtual training similar to this one on the 21st at 6 p.m. It's a really great way. We're preparing all of our volunteers to know where to go, what to expect, what information they need. But this is the best possible way that you can get really involved on a really local level and make sure that our community is just doing right by our other community members. So I would highly recommend, and we would love for you guys to be there. It'll be a great way to get ready to get this implemented into law. So, and lastly, thank you guys so much. It really means the world to us that you guys are here. It was awesome spending this past hour with you. If you'd like to reach out to us at a later date, here's how you can. Yeah, thank you so much. Depending on the time, I think